JonesWorks wants to add a defendant. Okay, I just started on this document that was uploaded to the docket, I think yesterday, maybe today. I got a notification today. Now it says filed 12/8. And I'm just at the beginning of the intro paragraph. And here's what we've found, okay? The Jones parties respectfully move for leave to amend complaint to file an wow, I can't read. I haven't had enough coffee. To file an amended complaint to add newly identified defendants, it's actually plural, and assert narrow additional claims based on facts that have only recently been uncovered in discovery that were not available before the deadline to amend. Now, I do think this is an interesting one. We saw how the judge felt about the deadlines from the hearing that this same Quinn Emanuel lawyer that's representing JonesWorks was a part of. The judge was not keen on their untimely delay. Wow, I have not had enough coffee. On them delaying serving the subpoena, right? We all saw that a week or two ago. The proposed amendments arise directly from documents and testimony obtained in the late stages of discovery, including evidence that the waiver parties withheld despite their discovery obligations. What do we think? Is this for PR? It's coming from a PR person. This is interesting. The Jones parties do not expect their proposed amendment or the targeted new allegations and claims contained therein to require any additional discovery. Okay, interesting. Or to affect the existing case schedule or orderly administration of this case. Obviously, deadlines are important to this judge, so I feel like she had to make that argument, but that's kind of interesting. You're going to add multiple defendants and say there's no additional discovery required. Also, that's a very one-sided argument. To the contrary, the new allegations and claims are supported by discovery already taken on the Jones parties' existing claims that has been thoroughly examined by the parties to date. Okay, but you're adding a new defendant, so, or it sounds like plural. They have rights too. The proposed amendment arises directly from documents evidencing that Nathan blacked out to harm Jones and JonesWorks, including by intending to use that article to try to black out. Here we go. This is where it gets good. The September 2025 deposition of a former employee of Nathan revealed that she and Nathan's instruction and in coordination, this is about what the subpoena was about, that Lyman didn't like too much. Because if you remember in the hearing, I'll have to go back to my video because I read through my notes. They mentioned the deposition. I don't remember if they said the name or if I'm just blanking on it. I know Nathan's was one, and then somebody else, maybe it was Brianna, was creating the website or drafted it at the direction of Nathan, and that was allegedly in contradiction with Nathan's statements. Okay, so they're going about it this way now. They've rerouted. At Nathan's instruction and in coordination with Jed Wallace. Okay, we have an idea of who they might be adding here. Are trying to add. Helped create the defamatory website about the Jones parties. But that website feels kind of like separate from all of this, right? I don't know why I'm also thinking about that Rebel Wilson, not Rebel Wilson, but the movie that she was in with that other girl, and then there was the website. I know this is about Stephanie Jones leaks. Oh, and here we go. Here's even more. The narrow claim added against proposed defendant Jamie Heath, who is already a named defendant in the Lively matter, arises from his production for the first time just days before his October deposition and nearly 3 months after the deadline of substantial completion of document production of an illegal audio recording of a phone call between Heath and Jones about facts at issue in the parties' existing claims. These cases just get uglier and uglier. Got PR written all over it, to be honest with you. I'm going to keep going through this, but what do you guys think?